We have breaking news tonight. A judge in Illinois has disqualified former President Trump from appearing on the state's Republican primary ballot. Cook County Judge Tracy Porter cited the 14th Amendment's insurrection clause in her ruling, ordering the state's election board to remove Donald Trump based on his actions on January 6th. Illinois is now the third state to disqualify Trump from 2024 primary ballots. The others are Maine and Colorado. As of right now, though, all three of these disqualifications are on hold pending a Supreme Court decision that could come down any day. Judge Porter acknowledged as much in her ruling tonight, writing that she knew her decision could not be the ultimate outcome. Now, whenever the court rules on this issue, it is sure to be considered in light of tonight's news that the court will now take up the question of presidential immunity in Jack Smith's federal election interference case. Joining me now to discuss all this is Mary McCord, former senior DOJ official for the National Security Division and an MSNBC legal analyst. Mary, thanks for joining me tonight. Some breaking news on all fronts. Let me first just get your thoughts on the immunity question and the degree to which the fact that the court is already mulling over the 14th Amendment case is at all a factor in the decision tonight on immunity.
Well, I know there have been people that have said ever since the court decided, to take up the 14th Amendment Section 3 question, and people listened to the arguments, and I think most of us who listened to them felt like the court is not prepared. There are not 5 justices prepared to bar Donald Trump from the ballot. They're concerned about a state having the ability to bar a presidential candidate from a ballot. I know a lot of people said, well, maybe they'll sort of balance that against a ruling either affirming the D.C. district in the immunity case or just not taking it up at all. I think, in the subconscious of the justices, those kind of balancing things out may exist, but I think they would very much deny that they do any type of horse trading like that, or that one case is related to the other in that way when the cases aren't technically related on legal issues. I do think it's interesting today to just think about the juxtaposition of this ruling out of Illinois with the decision to take up the question presented by the Supreme Court. So the question presented is the question that the Supreme Court has limited their review to is whether a former president enjoys immunity from criminal prosecutions for things that were within his official acts as president. So that we typically think of that from based on the law that applies to immunity in civil cases. Things that are within the outer perimeter of a president's official acts may receive immunity, but that question's never been asked for criminal cases. So when you think about what are a president's official acts, and on the same day as this decision to take up this case, we have a court in Chicago or in Illinois, like courts in other places, who have said Donald Trump engaged in insurrection. Just thinking about engaging in insurrection, the very thing that his criminal prosecution in Washington, D.C. is based on, engaging in this entire scheme that led to insurrection. It's hard to even conceive of that scheme as being within a former president's official acts. So the Supreme Court could have handled this much differently and said, we don't have to address questions about, in the generic space about whether a president could ever be immune for prosecution for things within the outer perimeter of his official acts, because here, this case in front of us is about a multifaceted conspiracy that led to an insurrection, an effort to overturn the votes of the American people. And whatever else you might say about official acts, that is not a president's official act.
Yeah, it just seems like the court has been handed a lot of data points, if not just very strong rulings, suggesting here's a person who fomented insurrection. Here's a person who has no claim to presidential immunity, according to the appellate court system. I mean, does it surprise you that they even feel the need to weigh in on this and that there was no noted dissent in the ruling today?
Well, you don't normally have a dissent from a grant of cert. You would have dissent sometimes from denials of cert, or you might have statements that sort of explain why cert was denied. So it would be unusual in the grant of a cert. I mean, a justice who is opposed to cert, there's a good chance that justice will ultimately be opposed to the ruling of the other members and can issue a dissent at that point. So I'm not surprised about that. I am surprised that it took almost 2 full weeks for them to decide to take this case I can't imagine why they couldn't have known immediately, justice by justice, whether they thought that the case was important enough to take. And, I've heard others say, and I don't disagree with this could have been an effort by some of the justices to actually convince others not to take the case. And maybe that's why it took this amount of time. They could have been also trying to hammer out what the actual question would be that they decided to take. But still, almost 2 weeks is surprising to me, and I think that's why a lot of us thought they would deny cert. In terms of my surprise about the justices, I think there's at least two who maybe want to side with the former president on this, or at least don't want to see him go to trial before the election. I mean, which is different than necessarily siding with him. But I think that most of the justices ultimately, I think, will come down on the same side that the D.C. Circuit did. And determined that on these facts, if they reach this, if they don't send it back to Judge Chutkan to determine whether this was within the scope of his official acts or not, but if they actually look at the facts of this case and address whether on a case with these facts that could possibly be immune from criminal prosecution, I think the answer will be no from a majority of the justices.
You sure would hope so. I know this is going to be the subject of an emergency episode of your podcast with Andrew Weissmann prosecuting Donald Trump, and I will be listening, Mary McCord. Thanks so much for your time tonight.